So I would start right away since we have time constraints as always. Many thanks to Judge Vegh. It was really interesting to hear your keynote speech, and we have now a very challenging panel also, I think, on the topic of immunities, which is a very crucial one. But before that, please allow me to thank Chantal Meloni, Flora Jesberger, Maria Crippa, and all the team that was organizing this wonderful conference. I think it was really a big endeavor, especially in this time of difficulties, and I thank you very much. It's indeed an honor being here. And also allow me just 30 seconds to give but I think our loving memory to Nino Cassese, because we're approaching the 10th anniversary of his passing. And actually, it's like he's here with us all the time. I mean, he has been evoked many times, even yesterday and today. And I think this kind of conference is exactly what he would have liked to be a part of, be gathering together scholars, practitioners, and NGOs, servants. And so thanks also for that. And thank you, Nino, you're still with us. Okay, now let me introduce very briefly the panel and the speakers. Of course, I will immediately give the floor to Alberto Di Martino. He's professor of general criminal law at the Scuola Sant'Anna in Pisa, but has been visiting also at Max Planck Institute in Freiburg and a fellow at the University of Hamburg. He has been a member of several commissions for the Italian Ministry of Justice, and is indeed very looking forward to hear his general introduction to the topic of immunity. So I will give you immediately the floor. Alberto, you have the floor.
Okay, thank you. Just 1 minute salutations in German, which is my love language. Liebe Freunde und Kollegen und Kolleginnen, sehr geehrte Damen und Herren, ich will mich mit Chantal und Florian für die Einladung herzlich bedanken aus zweierlei Gründen. Erstens, weil ich kein Humboldt-Stipendiat bin. So, es ist wirklich eine Ehre, an diesem Kolleg teilnehmen zu dürfen. Und zweitens, weil ich, wie Sie wohl wissen, kein Experte bin. Die Einladung kommt sicher aus Anlass einer langjährigen Freundschaft, für die auch ich sehr dankbar bin. Let's go down to business in English, no panic. I will, so I'm not going to give you a descriptive account of the present state of affairs, which is, according to many scholars, for example, to put it with the words of Douglas Guilfoyle, rather depressive. I take here for granted the mainstream approach to immunities, especially to functional immunities from foreign criminal jurisdiction, as well as the divergent conclusions on the existence of a rule exception relationship and on the contentious customary nature of both rules or exceptions to immunity. Frankly, to a non-scholar of international law like myself, it is striking to read, for example, in the textbook of Florian and Gerhard Werle-Jesberger textbook, that the irrelevance of immunity ratione materiae before both international criminal courts and foreign domestic courts is firmly established in customary international law, and then to read in the proceedings of the ILC that highly respected scholars of international law maintain that national case law, national statutes, and treaty law do not support exceptions. What do experts do of this different practice? This is a quandary. So I now rather intend to give some methodological inputs for discussion, at least I hope so. Of course, I won't refrain from expressing my personal views on the substance. I will first focus on the fountainhead of immunity, the idea of equality of states and argued that it must be read in light of the complex normative commitments of contemporary international law. And the second part of my speech will deal with a suggestion, the suggestion to strengthen the legal argumentation on immunities with a great deal of historical insights. So let's consider first the topic of immunities as we were looking at a tree with a trunk and with boughs. The trunk, I mean the rationale of immunity, both of states and individual immunity of every kind, functional or personal immunity. The trunk is the rationale, and the lateral boughs of the trees are the different types of immunity. I'm going to focus now on the trunk. What is the rationale of immunity? Well, the core foundational principle of immunity is sovereign equality. So the current explanation of that is to differentiate from acts involving the exercise of sovereign power, acta iure imperii, subject to state immunity, and other acts of state, especially economic activities, which are not. Acta iure gestionis. In concrete, it may be difficult to distinguish them, but in principle, so the red line of distinction is clear. Let's therefore first consider the first branch stemming from the trunk of the idea of equality of sovereignties, state immunity from foreign criminal jurisdiction. The ICJ, as you may well know better than me, stated that state immunity for acta iure imperii is a customary one, to which crimes under international law are no exception. However, so I maintain that the ICJ understates the last 70 years or so and the enrichment of international law through many complex normative commitments. The problem is not that state immunity is to be reversed as a matter of principle. A tissue is a different problem. Is just whether a principle dating back, that's my first historical suggestion, dating back to feudal Europe, when courts were just servants to the king, can be put in balance with other relevant principles that acquired equally fundamental force. The problem is whether to balance or not. International law has nowadays a range of normative commitments that have a legal force that equates at least the traditional imperatives of general principles, international law like pacta sunt servanda, to sovereign equality, as Palombella has written. The Italian Constitutional Court acknowledges the conflict, this conflict between rules of merit, jus cogens type of crimes, and immunity as a rule of procedure. It then goes a step further in the judgment 238 of 2014. It strikes that balance. While the court recognizes the immunity principle, it cannot uphold in the case at stake that specific rule implementing the principle so as to cover mass crimes. While sacrificing such a strict rule of immunity in case of mass atrocities would hardly undermine the core significance of state equality, making that rule to prevail over fundamental rights involved in case of international crimes under international law would instead impair that their core normative content. So the reasoning of the Italian Constitutional Court is based factually on a kind, we can use a new expression, on a kind of interlegal reasoning. All rules claim validity, both the immunity and the rule of making enforceable fundamental rights. And all rules are to be applied without a principal hierarchy to the case at stake, balancing, however, them in light of an interlegal method. Even the logic of counter limits of the logic put forward by the Italian Constitutional Court contributes to the development of international law. So let's turn to the second part of my speech. There is no hierarchy, I have said, no hierarchy between among international law components. Therefore, I agree with those who maintain that the argument based on the prevalence of jus cogens or cogens, if you want, is not convincing. As to the argument that international crimes, let's say crimes under international law, according to the notion put forward by Florian and Gerard Wehler, can never be encompassed in the notion of official acts. As to that argument, that international crimes cannot never be intended as being official acts, it has been objected that this account would lead to the conclusion that they are private acts. I'm not convinced by this objection, since the alternative is not official versus private. The alternative is between official acts in a very precise legal sense of acts strictly related to sovereignty in the sense of a legitimate exercise of typical governmental power on the one side, and acts factually carried out by the sovereign power against individuals in an illegal context amounting to the contextual element of an international crime. Such acts are actually acts of a state, as Michaela, for example, maintains, but they cannot be deemed to be the exercise of a legitimate typical sovereign power. On this basis, I am of the opinion that the whole discussion deserves a new starting point from a threefold point of view, from a threefold approach, a historical one, a conceptual, and a positivistic one. First, the historical point. I think one should take an historical approach and ask what the actual notion of foreign criminal jurisdiction is in relation to the content of the rule of immunity. Immunity for what? Well, immunity was historically, as such, not the rule, but the exception. Immunity is an exception to criminal jurisdiction of a public civil authority. And as exception, it has been conceived of in times where criminal jurisdiction was purely parochial, bound to the state territory. Therefore, it only applies to the protection against domestic criminalization choices, against ordinary crimes. Since criminal law has long time been merely domestic and territorial, and no notion of crimes under international law had been actually developed throughout the centuries from the birth of the nation state in late medieval times to Nuremberg, for this very historical reason, it is logically impossible to maintain that the purview of the rule of immunity extends beyond the remit of ordinary crimes, domestic crimes. The discussion about the rule exception relationship and the customary nature of, in particular, the immunity from foreign criminal jurisdiction in cases of crimes under international law, and the nature of the purported exceptions to it, obliterates these historical facts and therefore is based on a flawed methodological premise that immunity from foreign criminal jurisdiction actually encompasses extraordinary crimes. I therefore contend that there is no rule at all of immunity as to crimes under international law. In other terms, I submit that no rule of immunity for international crimes can have developed, since there is no state practice as to submit such crimes to any domestic jurisdiction, not even the home jurisdiction. It is neither ascertainable nor that immunity extends to international crimes, nor that it does not cover them. Regarding the first limb of the issue, immunity as to international crimes, the account that there is such immunity is deprived of any historical foundation. Consequently, the statement that it is of customary nature is abusive. I put it just for discussion. I know that this account is naturally is very controversial, can be very controversial, but I take discussion seriously and therefore I put it on the table. As to the second limb, jurisdiction as exception to the rule, the question, if the first point is clear as I put it, the question is moot. Consequently, I do not see any utility in the inquiry on the customary nature of such purported exception. This historical argument has to be strengthened through a conceptual and a positivistic argument. Let's move to the conceptual. I propose to slightly rephrase the rationale for functional immunity. The main problem here is functional immunity, immunity ratione materia in case of crimes under international law. To quote the words of Florian, all acts involving the exercise of sovereign power, acta iure imperi, are subject to immunity. That's the general purported rule. This definition should be modified, I think, as follows. Covered by immunity are all acts involving the legitimate exercise of a typical governmental power. Immunity covers only the legitimate exercise of typical governmental powers. Are international lawyers, are international criminal lawyers prepared to accept that crimes under international law amount to a legitimate exercise of a typical governmental power? Aren't they? I don't think so. Let's move to the last argument. I take time constraints seriously. A positivistic argument. I want to introduce, let's say, a different concept of sovereignty. What does it mean, equality of states? What does it mean, sovereign equality? I want to introduce the concept of conditional sovereignty. Immunity is related, no doubt, to sovereign equality. This principle, however, no longer refers to absolute sovereignty, but to a more nuanced or relativized concept of sovereignty, such as that introduced by United Nations General Assembly in 2005 on in the resolution on responsibility to protect. So I move, I shift from a purely international legal argument on the duty to extradite, to either to proceed or to extradite, to a more general, let's say, rex philosophisch or political philosophy argument. This is I adapt this concept of sovereignty conditioned by the responsibility to protect as a conditional sovereignty. This is a new conceptual, this is not only a rule, it's a new conceptual framework of existing international obligations that require states to refrain and take a number of actions to prevent and punish genocide, war crimes, I'm quoting, ethnic cleansing, and crimes against humanity. This is no longer a question of hierarchy levels with the jus cogens being at the top of the pyramid. This is a different concept. Abiding by these obligations is rather a precondition for recognizing equality of states altogether, Rechtlos in German. Committing crimes under international law makes the exercise of sovereignty illegitimate, and therefore this behavior does not meet, in terms of political philosophy, the implicit requirement of the new modern concept of conditional sovereignty. We are no longer within the idea of equality of sovereignties. This concept is not Tatbelsens message, sozusagen. A final apology in being perhaps radical, unorthodox, and I followed up the historian Dennis McSmith in the preface to the History of Italy. He is a coward or a dullard who does not risk some interim judgments on the course of history. For having been too much assertive, please forgive me. I could attribute this attitude to time constraints, but it wouldn't be entirely true. This is due to the conscience I have that the topic is beyond the outer bounds of my expertise, and I'm traveling along the coasts of immunity as a recreational boater. Thank you.
Many thanks, Alberto. I think you actually manage also speaking for under 20 minutes to give us a lot of food for thought, a lot of arguments. And I think that's, you won't be surprised because, we have discussed this before. I think that's exactly what we have to do with immunities, going back to square one, rethinking the rationale of immunity. Otherwise, we're not getting out of this conundrum. I think it's very important to make this exercise. And I will now give the floor to Michele Pifferi. He's professor of history and medieval law, medieval and modern law, at the University of Ferrara, and his research interests focus on history of criminal law and criminology. So I think we will hear other very interesting thoughts on the historical origins and development of immunities. So, Michele, you have the floor.
Yeah, thank you.
And you have 10 minutes, let's say.
Yeah, yes, of course. Okay. So thank you, Michaela, and thank you, of course, to Florian and Chantal, and also to Maria for inviting me. As you said, I'm a legal historian, so I think that my only way to contribute to this panel and to the conference is to sketch a few thoughts based on historical considerations, which may seem somehow unrelated to our topic, but I hope they will be somehow useful for our discussion. So the first point relates to the notion of immunitas in late medieval doctrine. And between the 13th and 16th century, immunitas was a key legal institution of the jus commune, regulating the relationship between the Catholic Church and the secular powers. It referred to the protection from secular jurisdiction, that is, prohibition of being arrested and prosecuted, for all the offenders who took shelter in a church or within a sacred place. Its underpinning political reason was to claiming the supremacy and independence of ecclesiastical spiritual jurisdiction over the lay power of kings, princes, city-states officials. Its finalistic justification was considered the belief that every offender and every sinner can be redeemed and their soul saved. But in order to achieve this purpose, the criminal who was within the walls of a church had first to be exempted from the secular justice, and there is often capital punishment. Within a late medieval legal order that has been depicted as a net of competing and intertwined powers, as a society without the state, or as a jurisdictional state in which the entitlement of legal authority was displayed not by the exercise of legislative power, but by the recognition of spaces of autonomous jurisdiction, the immunity rule tried to sanction the universal and prevailing jurisdiction of the church. However, as it was often the case in medieval law, the rule had many exceptions. For example, it contrasted with another general principle of criminal law, which was both ecclesiastical and temporal, according to which crimes cannot remain unpunished. The Latin brocardo, quite famous, was ne delicta remaniant impunita. The balance was found by doctrinal and customary rules in the idea that in case of the most serious offenses, they were called crimina atrocia, immunity should not be applied. Another exception was related to a political factor. So the more the state enlarged its sovereignty, the more the exception increased. Historically, with the transition from the Middle Age to modernity, which means from a pluralistic order to a monistic one, the consolidation of state sovereignty led to the disappearance of immunity, replaced by the absolute and complete territorial jurisdiction of the state. What we are witnessing since the Second World War is a reverse process, in which the immunity of state officials and bodies suspected of the commission of serious international crimes is gradually eroded by the growth of a new universal penal jurisdiction. What now seems to represent one of the most symbolic and resilient corollary of the nation-state sovereignty is challenged by an international penal justice whose purpose is exactly to counterbalance the Leviathan. Another difference seems noteworthy. In the jus commune, the immunity rule applied to places and not to individuals. As it is known, the medieval legal order lacked any idea of individualism and even less of individual rights. With some oversimplification, we could say that even the international customary rule of immunity is designed not to protect individual rights, but the personality of the state. The real turning point, and what seems significantly new from my historical perspective, is not a way of balancing different powers and jurisdictions within a differently shaped hierarchical legal order, but the centrality of human rights as the key factors laying behind this change. A second thought. In medieval law, the notion of immunity of the sovereign or any public power as completely beyond the law was not conceivable, because the constitutional framework of that legal order was grounded not on legal provision, not on legal positivism as expression of the king's will, but rather on natural law, on traditional and customary laws rooted in the history of a country or a nation, and therefore untouchable by any public authority, and on the scholastic rationalism of St. Thomas. As long as the public power was conceived of as inherently limited, the problem of immunity, as we have seen, had a different meaning referred to jurisdictional boundaries. When, by contrast, in continental Europe, the sovereign started being theorized as an absolute power, legibus solutus, so it means since Baudin and since Hobbes, the state and its representative started being considered as immune from any prosecution because, as being above the law, they could not be subjected to the law. After Westphalia, this characteristic of the state shaped the origins of the international law and the immunity rule par imparem non habet judicium. The English constitutional history of the rule of law, with its dualism of gubernaculum and jurisdictio, described by Bracton and analyzed by McIlwain, provides a possible different conceptualization of sovereign power. In the rule of law model, the king is not the only absolute authority, because the independent judiciary not only contributes to create positive law, but also operates as a limiting check to the king. The sovereign is not legibus solutus, has not complete immunity, but can be responsible of violation of the law of the land before the judiciary. There is, to put it briefly, a principle of accountability based on the idea that a jurisdictional power can control, can limit, can prosecute the king by balancing its prerogatives with other legal principles and norms. If we de-historicize the rule of law and think of it as a model, it may be usefully applied to the immunity issue. In its core, what we are witnessing at an international law level, as well in the some national constitutional court decision, is an effort to overcome immunity rules for international crimes and make the state and its official accountable, in order not to betray the promises of international criminal justice, to bring before justice those responsible of atrocious crime, and not to deny the victims' demand for justice. A final point. Another key word whose meaning has changed over centuries and whose conceptual history may be of some interest for our discussion is that of dignity. In some medieval sources, both legal and theological, as has been shown by Kantorowicz, the concept of dignitas was a cornerstone of the king's two bodies theory. The king's dignity, which could never die, represented his public, immortal, sacred, and perfect body, namely the fictio iuris to legitimize and give a definition of the sphere of the sovereign's public power. Dignity was, again, a concept whose fundamental legal meaning was completely and intentionally disconnected from any consideration of the individual human being. With a radical and gradual turnaround, human dignity is today one of the protected and fundamental values whose gross violation in the form of international crimes should allow their prosecution irrespective of personal immunities of even incumbent heads of state or high-ranking state official. As long as dignity was referred to the public body of the state, it entailed an idea of immunity as manifestation of its superiority. If dignity becomes an individual human right to be protected, the immunity rule should also change accordingly. I think I stop here. Thank you for your attention.
Thank you very much, Michele. I think you're already in the first two speeches. We are, the paradoxes of immunities, as we can call it, are coming out. So I think it's really interesting to, again, to reflect in this direction of showing the contradictions and see how we can find ways to evolve from, these contradictions. And I immediately now give the floor to Chiara. Chiara Ragni is professor of international law here at the University of Milan. She has been studying international criminal law issues for a while, and she was also a member of the Progetto Cariplo, headed by Fausto Pocar. So I'm again looking forward to hear her comments. So Chiara, you have the floor.
Thank you, Michaela. Good morning, everybody. Let me use one of the 10 minutes at my disposal for expressing my gratitude to Chantal for her invitation and for congratulating her and all the organizers for putting in place this impressive, very interesting conference, which addresses urgent and fundamental topics such as, for what concerns this panel, the question whether immunities from jurisdiction also apply in criminal proceedings regarding international crimes. As already noticed, this issue is highly controversial, as it results also from the works of the International Law Commission on the topic, which resulted in the approval in 2017 of draft articles on immunity, which was adopted by a majority vote, which is quite an unusual situation. And among the main objections raised by the members, some of them argued that the Commission, more than reflecting customary rules on immunity, expresses a sort of legislative politics on the matter. I think that the point has already been touched by Alberto. What are the main, what was the most problematic provision in these draft articles? For sure, Article 7, which provides that immunity ratione materiae from the exercise of foreign criminal jurisdiction shall not apply in respect of crimes under international law, namely genocide, crimes against humanity, war crimes, crimes of apartheid, torture, and enforced disappearance. According to the objections raised by the members of the Commission, this provision does not reflect an appropriate balance between, on the one hand, the need, the interest of the international community as a whole in preventing and punishing the most serious crimes under international law, and on the other, the sovereignty or quality of states and the need for stability in international relations. They in particular expressed concern that the limitations and exceptions to immunity proposed by the Special Rapporteur could pave the way for abuses, for example, by enabling politically motivated trials of state officials in foreign jurisdiction. So that they also proposed, they also suggested that the argument, the topic of immunity should be postponed and treated together with the question of procedural guarantees in domestic proceeding. I do not mean to go over the different arguments put forward by the members of the Commission, but just to make a few comments on the topic, starting from the cornerstone of this issue, which is the rationale of functional immunities, a topic which has been already touched by Alberto, but I think that we have maybe different perspective. This kind of immunities, functional immunities, cover official acts, namely acts performed by state agents on behalf of the state, and as opposed to personal immunities, they only covers the official acts, not the position of the officer. And so, as such, they may be relied on by all who have acted on behalf of the state, on the assumption that acts committed by state agents acting in their official capacity does not belong to the individual himself, but they belong to the state on which behalf they acted. And since states enjoy immunity from foreign jurisdiction, this immunity also extends to official acts performed by state agents. Since functional immunity only covers public acts, and so private acts are excluded, some proposed to characterize international crimes in order to exclude the application of functional immunities with respect to such crimes, to characterize them as private acts. I think that this argument is not convincing, since international crimes are often committed as a part of a state policy, and some of them, let's think about torture or enforced disappearance, imply the participation of state agents as an element of the crime. I think that the most persuading argument for excluding immunity with respect to international crimes is more grounded on the principle of individual responsibility. This principle was first affirmed by the Nuremberg trials, and where it was stated that crimes against international law are committed by men, not by abstract entities. This implies that, as regards international crimes, the traditional rules of attribution, which postulates that official acts of individuals acting on behalf of the state belongs only to the state, does not apply, with the consequence that functional immunity, which is, according to the proposed perspective, a necessary corollary of that rules, does not apply too. So the principle of individual responsibility does not imply that the state is exonerated from any responsibility with regard to international crimes. On the contrary, states have an obligation to prevent and to prosecute international crimes. An obligation that, since so far it is aimed at protecting fundamental human rights, is due not to a state or another, but due to the international community as a whole. Excluding the application of functional immunities in this context, in my opinion, is a means of ensuring the fulfillment of this obligation, because even if there are international tribunals like international criminal tribunals or a judicial or quasi-judicial body dealing with human rights and with their violation, I think that these bodies cannot exercise their, they don't have both the capacity and the jurisdiction for addressing all the possible human rights violation. And so domesticating international criminal law, meaning considering national courts as the best place for prosecuting international crimes, in my opinion, should be the way. National courts are closer to the victims, closer to the evidence. They sit in the territory where the crimes are committed. But prosecuting crimes before national jurisdictions may prove very difficult, especially in the case where national courts are called to judge officials of the same state where they sit. So attributing the possibility to foreign jurisdiction to prosecute international crimes maybe can be a way of overcoming, of circumventing these the problems, and of, as such, of ensuring that international crimes that are the most serious crimes do not go unpunished, and of ensuring that victims can obtain justice. Thank you for your attention.
Thank you, Chiara. Thank you, Chiara. I would have a lot of thoughts, but I will refrain myself. Apart from, you know, what you were mentioning at the beginning, it was making me think a lot about the attitude of the International Law Commission, because in fact, as you were saying, you know, they were supposed to codify or at least engage in progressive development, while here it's more like regressive development of international law, you know, at least on this topic. Okay, so now, but before you know, opening also the floor for remarks and for comments, I will give the floor to Valeria Vegh. She's professor of criminology and transitional justice at the University of Buenos Aires and the National Quilmes University. I hope I'm pronouncing it well. She's also a research fellow at the University of Constance in Germany and associate at the Max Planck Institute for European Legal History, where she co-directs a research group on transnational criminal law in transatlantic perspective. So Valeria, you have the floor for the final speech, and then we are opening of course, the debate.
Thank you very much. And of course, I want to thank Florian, Chantal, and Maria for this great conference. So my comment will point out to two social legal dimensions on immunities. First, on the misuse of the neocolonial narratives to ensure immunity of heads of state in some African countries. I will base my thoughts on the Kenyan case before the ICC. And second, very, very briefly, I will point out that something that Professor Ragni has just mentioned, the symbolic nature of immunities as a privileged example of how ICL targets individuals, but sometimes misses to expose the eventual criminogenic nature of the state. So let's go directly to the first dimension. As I said, the misuse of the neocolonial narrative to legitimize immunities of heads of the state. And I will base these reflections on the work that I did in Kenya between 2016 and 2017, when I worked on the transitional justice process with Serge Brammertz and the ICTJ. So very briefly for the people that are not aware about the Kenyan case, the Kenyan transitional justice process followed the 2007 massive violence that occurred during the presidential elections, when delays in announcing the results led to violence between people from two opposite parties, which are also divided according to ethnic lines. And in that context, security forces, informal militias, and ordinary civilians exercised violence against each other, not by themselves, but encouraged by the political and ethnic leaders, the media, and also business people. Overall, the result of this violence led to 1,000 people that had been murdered, at least 900 people suffered sexual violence, and almost 700,000 people were displaced. All this process became known as post-election violence. So the formal transitional justice process took place in 2008 when, while still violence was going on, the two main political parties agreed to seek mediation by a panel of eminent African personalities under the chairmanship of former UN Secretary General Kofi Annan. So what happens in terms of justice in this transitional justice process? Well, it included the enactment of an International Crimes Act in 2009 that incorporated the Rome Statute. So Kenya is in the forefront in relationship with Italy, but things didn't went well, so let's not worry. Already, the Rome Statute had already been ratified in 2005, and it defined crimes against humanity and other crimes under international law as crimes in domestic law. However, there were problems in terms of retroactivity. So offenses committed before the enactment of the law, so the ones that occurred during post-election violence, could not be judged as international crimes. Then there was no solution in terms of accountability. Civil society organizations then proposed to appoint prosecutors and investigators, demanding that they should be truly independent and knowledgeable in international criminal law and international law, hoping to replace the biased and party-aligned existing judicial authorities. However, the members of the parliament, many of whom were also involved in the crimes, dismissed the proposal and pushed to bring prosecutions to an international arena under the slogan, "Don't be vague, let's go to The Hague." Because the understanding was that the ICC will only focus on really big fishes and not on them. Nothing happened at the end at the domestic level. So Kofi Annan did hand over the evidence to the ICC chief prosecutor. And on November 26, 2009, under Article 15 of the Rome Statute, the prosecutor requested authorization from pretrial chamber 2 to proceed with an investigation. Following a 4-month review of the prosecutor application, the chamber granted the request, and the case included the maximum leaders, including President Uhuru Kenyatta, who was in power. After the ICC initiating investigations, the Kenyan government tried to undermine the process, completely disregarding Article 5 of the International Crimes Bill of 2005, which obliged Kenya to cooperate with the court. Furthermore, in 2010, the Kenyan parliament passed a non-binding motion urging the government to withdraw from the Rome Statute. In February 2011, the government also tried to make the UN Security Council to postpone ICC involvement. But in what is the focus of our panel, the interesting moment came up when the pretrial chamber of the ICC issued summons requiring the 6 accused to appear before the court. In this context, to defend immunity, the immunity of the head of the state, the Kenyan government and the opposition gathered, and together they initiated a new strategy, delegitimizing the ICC as a neo-colonial intervention aimed at smashing the immunity of those heads of state from former colonies. And that was the success of this neo-colonial narrative strategy that the defendants from the 2 former confronting parties who have been at the forefront of the violence ended up united and casting themselves as political victims of a national and international conspiracy against them, returning significant public support in their ethnic regional communities. On top of that, the government also successfully soaked up the support of the African Union. In 2013, as you may know, in an extraordinary session of the Assembly of Heads of the State and Government, the African Union issued a series of decisions stating the need to safeguard the constitutional order, stability, and integrity of member states by ensuring that no charges shall be commenced or continued before the International Court against African Union states. And the African Union also decided that President Uhuru Kenyatta in particular would not appear before the ICC. In this vein, the ICC charges against Kenyan power holders redouble the hostility and the belief that the court only focused on the African continent. Indeed, aside of the underlying pursuit of impunity by some heads of the state, the African Union's suspicions regarding the potentially unfair discretional case selection of the ICC might stand, of course, on reasonable grounds. Actually, when confronted with this accusation, the former ICC prosecutor, Ocampo, explicitly admitted that he would not apply the same remit of justice to cases in Chechnya, Iraq, or Afghanistan, because this would be politically difficult due to the political interest involved, including the participation of the United States and Western Europe in the human rights violations. The situation between the African Union and the ICC finally escalated when in 2014, the annual summit issued the Malabo Protocol, of which we talked yesterday, extending the jurisdiction of the African Court of Justice and Human Rights to cover international crimes along the lines of the Rome Statute to make the ICC dispensable. Within this context, the Ugandan president referred to the ICC as a bunch of useless people, and the Rwandan president said that the court was never about justice, but about politics. In 2016, the president of Burundi, Gambia, and South Africa expressed their intention to leave the ICC, and Burundi effectively did so. Overall, the scarce domestic criminal trials combined with intense anti-ICC propaganda under a neo-colonial stand and the undermining of the court's evidential efforts created a legal environment that made it extremely challenging to continue with the initial criminal proceedings against Kenyan power holders. The newly appointed ICC prosecutor, Bensoara, ended up withdrawing the charges against the Kenyan leaders. So the Kenyan case is crucial to discuss immunities as it raises relevant socio-normative questions around this fundamental topic, which demand a thorough discussion. Because of course of time constraints, I will only post some inquiries that we can discuss later. How can international law and international criminal law regulate and enforce immunities without this being distorted as a neo-colonial intervention in disrespect to the African country's sovereignty? Second, might it be the case that a more even application of ICL can serve to overturn the neo-colonial narrative and ensure that immunities are not an obstacle to accountability? Third, how does the ICC intervention in Darfur plays out in this context? And finally, might it be that the inclusion of historical injustice and neocolonialism as a legitimate subject of ICL can make a difference in terms of its legitimation before the Global South? And to close my comments, and really very, very briefly, let me introduce a second socio-normative dimension on immunities, that is the more structural problem or paradox of immunities and ICL. Micaela suggests in the last part of a very, very recommendable article entitled On the Existence of a Customary Rule Granting Functional Immunity to State Officials and Its Exceptions, back to square one, that immunities hide a paradox. That means that even when it has often been said that state officials may not hide behind claims of state sovereignty to escape criminal accountability, she argues that maybe the situation is exactly the opposite. Indeed, states may be the ones that are hiding behind individuals, because only the latter, at the end of the day, may be persecuted before the domestic criminal court or the international criminal tribunals. There are some exceptions to this trend, such as the International Military Tribunal, the IMT, in post-war Germany. As we know, in the final judgment, entire state agencies, including the Gestapo, the SS, and the Nazi Party Leadership Corps, were framed as criminal organizations. So the state, part of the state, were framed as criminal organizations. However, this is not the rule. Generally, international crimes are framed as contextual based and target very specific perpetrators. The result, as the Kenyan American scholar Makau Bamuto explains, is that once that bad apples are separated from the rest, the state remains as a clean institution. This is particularly worrying when ICL fails to prosecute high-ranking perpetrators and focus on the middle or even the low-ranking bad apples, leaving the rest of the state agents and the state itself untouched. The question is then, how can we go beyond the individual features of ICL accusations to uncover the state responsibility for international crimes? How can we address a full discussion about immunities without disregarding the broader picture of the straight criminogenic structure. Again, time constraints do not allow for a full exploration of these inquiries. However, I want to point out two possible pathways. First, the holistic analysis of transitional justice, in which accountability and criminal justice cannot be isolated from reparations for the victims, the seeking of truth, and institutional, legal, and cultural reforms to avoid repetition. Second, more innovative concepts, such as the one of transformative justice, might be a necessary component of a truly engaging transitional justice that can bring more comprehensive perspectives on ICL in general and immunities in particular. Thank you very much.
Thank you very much, Valeria, for widening also, again, the scope of our reflections, including rightly the transitional justice dimension and also the issue of narratives, which I think it's very, very important in general for international criminal law issues, but especially for the issue of immunities. I don't know, I'm looking to Chantal. Can we have 10 minutes for the debate? Okay, 10 minutes, it's fine. So I open the floor immediately, and Chantal, you have, okay. Diritto di privato.
Thank you so much. I'm very practical here, and I don't know exactly to whom I should ask this question. Maybe Alberto, Micaela, and Chiara. So my question is, imagine tomorrow the Italian judges have competence on international crimes. Do we have a problem of immunity if the defendant, the suspect, is someone that could enjoy functional immunity? The German solution was to rule out basically the relevance of immunity for the commission of international crimes. And yeah, Florian can tell better, the last decision by the Bundesgerichtshof, right, of March, February 2021. My question is, what about our system?
No. Thank you very much. Actually, that was exactly my question also. I was just out of curiosity. I mean, it's in a certain way, of course, theoretical question, perhaps I understand at the moment, but yeah, the point is, as we think, I mean, 10 years ago, nobody would have thought that we would sit here now and discuss the issue whether there would be at all functional immunity or no exception, in fact, for functional immunity in these cases, because it was, at least to the practitioners and to everybody working on that issue in Germany, quite clear. We had this sort of, let's say, argument with regard to the ICC to some point, but in the national practice, we didn't really have this issue. It changed, as we have heard, with the debates in the ILC, where we also, perhaps to be clear, have to say it is and has been a small minority of members of the commission, particularly the Russian members and the US members, and sorry to say also my faculty colleague Georg Nolte, who pushed for that issue and who made us in a way sitting here now and say, well, it's really an open question. So, which, I mean, at least to me and to some, and Andreas Zimmermann actually addressed it yesterday in his speech also as an international lawyer, comes as a surprise. So I just want to support that. And just one sentence on the situation in Germany, where we just, as Chantal correctly mentioned, had a long judgment by the Federal Supreme Court confirming the decade-long practice of prosecutors and courts in Germany that there, of course, is an exception to functional immunity. So it was only about functional immunity. And as Andreas Zimmermann mentioned yesterday, the Federal Supreme Court, the Senate, was so sure and convinced of his position that he did not even submit this question to the Constitutional Court, which the Senate should do in case there is any doubt. So there was not even any doubt whether there would be such a rule under international law. Technically, just last sentence, sorry, we don't have a lot of time. So technically, German procedural law refers to international law. So it's actually decided on the level on international law, and then there is a reference to international law in a certain piece of legislation which is applicable to the criminal courts. So thank you very much. But just want to say I appreciated very much also the historical and the conceptual considerations we learned, and I completely agree also with what Michaela Frulli said. It is important in this situation to go back and remind us of where it all comes from. And so it's much appreciated. Thank you very much.
I don't know if there are other comments or questions from the floor. Shall we start answering? I don't know who wants to speak first or. Okay. No, it's, actually, we don't have an answer. I think it's customary law, so it depends on the interpretation of the judge. If there is no legislative provision, the judge will have, as they have interpreted the rule on state immunity, they will have to interpret the rule on functional immunity. I'm hopeful that they will. I mean, and they have been in the past conflicting interpretations, because they applied functional immunity like in the Lozano case, but we have other cases like, for instance, with consular agents or so, where they were not applying the functional immunity because in fact the acts were not falling within the proper exercise of consular functions, so to say. So I think we have room for that. Either there is a clear legislative stand on that, or there is room for interpretation, and hopefully, I agree with you. It's actually a minority of scholars also within the ILC pushing towards the idea that there is no exception, or that the basic rule of functional impunity applies to all kinds of state officials, which is doubtful. I think I agree with Alberto. I don't think there is a universal customary rule applying to all state officials. It's not coming out at all. Having studied the jurisprudence of several countries for many years, it's not clear at all the panorama. So, but Alberto.
Yes, I'm Professor Vegh, I beg your pardon. I now, let's say, and I try to occupy the position of a constitutional judge and say, my message, oh, sorry, I ideally occupy the position of a constitutional judge, and I would say, please be courageous and say, well, one must be really realistic, but I would say it is not important the question whether there is an exception or a rule. Be it an exception or a rule, let's stick to the proposition that there is immunity. There is no functional immunity in case of international crimes. However, there is personal immunity. The rationale of these two branches is different. So in case of I would say it is a head of state, so he enjoys personal immunity, but no functional immunity. The motivation of the judgment is of huge importance in that case, even if we think that the motivation contributes to the development of international law. So I think a constitutional judge should say, well, he doesn't enjoy functional immunity if the case the person enjoys personal immunity. The motivation is that there is a clear rule or clear trend of international law. Being realistic, I would say, if the judgment of our Constitutional Court 238 of 2014 has to be pushed to its logical consequences, I dare to imagine that the Constitutional Court will decide against enjoying functional immunity. I hope the Constitutional Court will motivate in towards this conclusion, and then you may resort to our constitution, to our automatic incorporation of international law, customary international law into our system, but this is not necessary. I don't think whether I have responded, but that's my position.
Thank you. I totally agree, but I give the floor to Chiara.
Yes, thank you for your questions. And I must confess that I expected this question from Chantal, because we taught together a course here at the University of Milan, and our perspective are a bit different on some problems, the principle of legality, and some other problems, because maybe the perspective of the international lawyer is a bit idealistic from the more practical perspective of a criminal lawyer. However, as Alberto said, the problem actually exists as regard higher ranking officials that are still in charge, because in that case, the personal immunity applies, and notwithstanding the regret of Michaela, unfortunately, this immunity is not overcome, even in the case of international crimes. But as regards to functional immunities, I think that, well, the objections that maybe a customary rule does not already exist may be well-founded, but one of the tasks of the International Commission is also to push the progressive development of international law towards what the Commission call a trend that we can observe according to the practice of some international tribunals, but maybe also the constitutional courts and the domestic tribunals themselves can take very important steps in consolidating this practice. This is why I suggested that the national courts should be the ideal place where international judges should be prosecuted. Thank you.
Thank you very much. I think Judge Aitala wants to say something. And I see also someone else.
Well, on this, just a very quick point. Seen with the eyes of the judges, this is not clear at all in Italy. If you take, for example, the Lozano case, on which also Nino Cassese commented years ago, this was the killing of a senior intelligence officer, Italian intelligence officer in Baghdad, after they had rescued an Italian journalist. One of the key points of that trial was both at the Corte di Assise, the first instance trial, at the Court of Cassation, the issue of functional immunity. And this was dealt with very badly, I have to say, because, for example, they started confusing the responsibility of the state and functional immunity, so responsibility on the individual. So my sense is that this matter would have to be dealt with clearly. Should we take the road to criminalize international crimes, as I believe should be the case, this needs to be clarified from the very beginning, because the Italian judiciary regretfully is not prepared on this, especially when customary law comes in. This comes from our mentality. We are normally used to go by the law book. If it's not in the law book, it's very complicated. So I feel that this is something that should be clarified from the very beginning, or it would be a big, big issue.
A quick follow-up. We do have a huge problem with preparation of judges in international matters, which has not to do with the clarity of concepts, but with the effectiveness of education in international matters of the judges. That's a problem of education, not a problem of concepts. I have said that many times at the Scuola Superiore della Magistratura, so I am not shy in repeating that in front of this audience. Thank you.
Thank you very much. I have, oh my God, one comment that is a question and one question that is a comment. I start with the first one. I believe that there is no functional immunity for international crimes, but I want to play the devil's advocate. I would like to ask you, what happens if the domestic legal system of the court before which I am brought considers genocide to be applicable in relation to political groups? So what happens if the definition of the crimes, international crimes, in that domestic legal system is not in line with international obligations? Is it fair that that state official has no functional immunity? You say you are being speculative. No, I'm thinking about the idea of the Kerala court in India to prosecute our Marines, the due Marò, for terrorism, to avoid the issue of immunity. They tried to argue that international terrorist is international crime, so there was no immunity. So first question, what we do if the definition in national legislation is not in line with the international definitions? The second question is very theoretical for everybody. Do you think that we can use the theory of countermeasures to justify a denial of personal or functional immunity before a domestic court when we talk about international crimes? Thank you very much.
So it's a very quick point. I agree that there is a need of a clear solution, but don't forget that every clear solution adopted by the legislator should be in line with Article 10 of the Constitution, which can be invoked to challenge this solution. So every possible solution must be in line with customary international law. And if there is disagreement among international, it's very much related to what he said. In fact, if the solution adopted by the Italian legislator is more advanced in a way towards the end of a more effective enforcement of international criminal law, then there could be problems with regards to the compliance with Article 10. That means with the compliance with the general rules of international law, which must be respected, because otherwise a legislative provision could be held unconstitutional. So there is a problem to be addressed at a constitutional level as well.
Then I leave to maybe the criminal lawyer. I don't know. I have one quick remark as an international lawyer. I think it's, I mean, customary law, in fact, it's not written. So in fact, I don't know, you cannot really fix it one day in written form. You can do that, but maybe then it evolves in a different direction. So in fact, it's very difficult to say the content of customary international law. I think, and you know, I think the problem of also we were speaking about this yesterday, of correspondence between different legal orders or differences that we may have is stronger, I think much stronger when it relates to the definition of the crimes, because there, especially as Marco was saying, there is a widening of the offense. It is a problem if it's not in line with the international definition. But as far as immunities are concerned, I think, again, I stand to be corrected, but you know, you have really to prove the existence of a general rule for the Marò. For me, they were not enjoying functional immunity on the basis of a customary rule. So what's the point? I mean, it's really difficult if you study the jurisprudence in depth to say that there is a general customary rule attributing functional immunity to all state officials because they were acting on behalf of the state. The rationale of functional immunity is not only this, but it's also related to the functional necessity, to the idea that they're doing something. So we have to look what they're doing. And sometimes we have treaty rules giving functional immunity, but not a general rule. So I think customary law is very controversial and hard to be construed, you know. So there is, you know, I think also a great margin of interpretation on national judges, as it happened when, you know, we were moving from absolute immunity to relative immunity. So the big part was played by domestic judges. So that's my point of view.
As regards you, I think I just, yes, I try to, I am not an international lawyer, I try to reason aloud. I have no personal idea. As regards the comment made by, the first comment made by Marco and the follow-up by Professor Vigano, what happens if the domestic label, the domestic definition is broader than the international customary one? I don't see any problem here if we are clear that we are not concerned with labels. We have to look at the Tatbestände, at the offense definitions. If genocide encompassing political groups, only political groups, is definitely clear that it does not amount to a customary international crimes. There's no customary law. So the definition is purely internal. The label is international crime of genocide according to domestic legal system. So we face here a domestic offense pro parte. It is, let's be clear as regards the component elements of every offense. Don't stick to labels, please. So if genocide is related in the domestic system to social groups or political groups, this is not a customary law. Definitely, that is definitely clear. So you may manage a purely domestic offense. Thank you. So therefore, conclusion, functional immunity, because you are facing domestic jurisdiction.
Yes. Well, I fully agree with Michaela and Alberto, so I will add just some consideration on your last question about countermeasures. Well, I don't think that prosecution of international crimes should be used as a countermeasure. So my answer would be no, it is not possible, but in theory it is. So the idea is that prosecuting international crimes, or better, claiming the violation of human rights, even if occurred in the territory of another country, should respond to the need that should felt as an imperative by all the states to protect human rights. So it is more complying with an obligation which is customary too, of protecting human rights, and which is imperative to, more than vindicating or reacting towards other states. And this trend is also, in my opinion, testified by the interstate claims with regard to human rights, which is also a trend of the recent years. And I think that the provision of draft Article 7 and the exception to immunity should be read in connection with and in coherence with international law in general, and also with this trend.